The Family Educational Rights and Privacy Act, also known as FERPA, was enacted in 1974 with the primary goals of granting eligible students and their parents access to students' educational records and restricting third-party access to those records. Congress passed FERPA in the 1970s primarily to address growing concerns about the privacy and accuracy of student educational records. Before FERPA, there were a few regulations in place to protect student information from being accessed without consent or shared indiscriminately. The increased collection, maintenance, and the use of student records by educational institutions highlighted the need for privacy protections. On the one hand, there was a growing concern that students' and families' privacy rights were being compromised by the lack of control over who could access and share educational records. There was a clear need to establish clear guidelines that prevented the unauthorized disclosure of student records, ensuring that student information was not shared without explicit consent, except under specific legally defined circumstances. On the other hand, before FERPA, parents and students often had limited or no rights to access educational records, leaving them in the dark about what information was being collected and maintained. There was a demand for a mechanism that allowed students and parents the right to review records and ensure their accuracy. FERPA was therefore enacted to establish the rights of students and parents to access and amend those records, and to set forth the conditions under which the information could be disclosed. FERPA applies to all educational institutions receiving federal funding from the U.S. Department of Education. Non-compliance with FERPA can lead to the potential loss of federal funding. On average, federal funds covers about 8% of the total funding for public schools in the United States, with the rest coming from state sources such as state income taxes, sales taxes, and other taxes, and the local sources such as property taxes. Over its history, FERPA has undergone several amendments to address evolving privacy concerns and technological changes that influence student records. What does an education record mean here? They refer to records that are directly related to a student and that are maintained by an educational agency or institution, or a party acting for or on behalf of the agency or institution. Those records include, but not limited to, grades, transcripts, class lists, student course schedules, health records at the K-12 level, student financial information at the post-secondary level, and student discipline files. The information may be recorded in any way, including but not limited to handwriting, print, computer media, videotape, audio tape, and email. Let me introduce a case about the education record. The case of Ellis v. Cleveland Municipal School District is about the disclosure of documents related to student-teacher altercations. In this dispute, the guardian of a student requested records to pursue legal claims related to allegations of physical altercation between substitute teachers and students. Specifically, the guardian sought to obtain information about incidents where substitute teachers were allegedly involved in physical abuse of students. The school district argued that those records were protected under FERPA, which restricts the disclosure of student records without the written consent of the student's parents or the students themselves if they are 18 years of age or older. The court concluded that FERPA is designed to safeguard student records, not teacher records, and that the information requested by the guardian was not educational records as defined by FERPA. The records in question were more directly related to teacher conduct than to any specific students and therefore did not contain information directly related to a student. Even if records were considered education records, FERPA does not outright prohibit their disclosure. It allows for the disclosure of such records under certain circumstances. In this case, the court determined that the student guardian's request for the records to pursue their claims justified their disclosure, emphasizing the importance of addressing allegations of abuse by substitute teachers. The court ordered the school district to provide responses to the student guardian's discovery request, including answers to interrogatories, admission or denials of request for admission, and the production of documents with the caveat that any documents released should have the name and addresses of minor students redacted to protect their privacy. This case highlighted that teacher disciplinary records or allegations of teacher misconduct are outside the purview of FERPA when they relate to the actions of teachers and not to students. Let's look at another case at the intersection of FERPA and the state open records law. In Easton area school district v. Miller 2019, a school bus surveillance video captured an incident where an elementary school teacher allegedly physically disciplined a child. A local news reporter requested the video under the Pennsylvania Right to Know law. However, the school district denied the request, arguing that releasing the video would risk losing federal funding because the video was considered an education record under FERPA and it contained personally identifiable information related to students. The Pennsylvania Supreme Court concluded that the video did not fall squarely in FERPA's definition of education records. The court made a key distinction between content that is tangibly related to students and content that's directly related to teachers' conduct. This differentiation is important because FERPA's protections are designed to safeguard student privacy by restricting the disclosure of records that are directly related to students and contain personally identifiable information. The school district's argument hinged on the assertion that the video, by virtue of showing students, contained personally identifiable information related to those students, making it an education record whose disclosure could potentially risk federal funding. However, the court scrutinized the content and the context of the video more closely. It recognized that while students were indeed present and visible in the video, the primary focus or subject matter of the video was the conduct of the teacher. This is where the court's distinction becomes important. If the video were primarily documenting an educational activity or a student's academic performance or behavior, it may more clearly fall under FERPA's definition of an education record. Instead, the video captured an incident of disciplinary action by a teacher, which, although involving students, did not primarily concern the student's educational experience in a way that the FERPA intends to protect. Moreover, the school district's speculative concern about losing federal funding did not outweigh the state open records law's presumption in favor of public access to records. The state open records law operates under a fundamental presumption. All records in the possession of a local agency, such as a school district, are considered public and therefore accessible to the public, unless specific exemptions apply. This presumption promotes transparency and accountability in governmental agencies by ensuring the public has access to information about the operations and activities of those entities. Against this backdrop, the school district faced a significant legal hurdle. The school district was required to demonstrate by a preponderance of evidence that releasing the school bus surveillance video would directly result in the loss of federal funds due to a violation of FERPA. A preponderance of evidence is a standard of proof used in both civil cases. It means that the school district bearing the burden of proof must convince the judge or jury that there is a greater than 50% chance that the claim is true. In this case, the school district did not meet this standard of proof for several reasons. First, there was a lack of evidence to show that the school district had a policy or practice of impermissibly releasing education records or personally identifiable information. FERPA's funding penalties are designed to address systematic violations of student privacy, not isolated incidents or singular requests for information under state open records law. Second, the court's analysis implied that a singular instance of disclosing a video, especially one that could potentially be redacted to protect personally identifiable information, would not likely trigger the drastic consequence of losing federal funds. This consideration is rooted in a practical understanding of FERPA's objectives and the Department of Education's enforcement practices, which focus on ensuring educational institutions maintain overall compliance with privacy protections rather than punishing isolated or unintended breaches. As a result, the court ordered the school district to disclose the video with the students' faces redacted. Move on to one more case. In the case of School Choice Ohio v. Cincinnati Public School District 2016, School Choice Ohio, Inc. was a private, nonprofit corporation that informs Ohio parents about alternative educational opportunities for their children, including publicly funded scholarships to attend private schools. School Choice Ohio relied on direct communication through phone calls, email, or mail. School Choice Ohio obtains the students' contact information by submitting public records requests to Ohio public school districts. In 2014, School Choice Ohio filed a public records request for student names, addresses, and other contact information. The school district released names and addresses, but denied other information such as parents' email addresses, telephone contact information, and students' grade levels for the previous school year. The school district argued that it would release only information that its 2012-2013 policy explicitly designated as directory information, which did not include students' grade levels or parents' personal information. This was because in the 2013 and 2014 academic year, the school district updated its policy on student information. In the new policy, the school introduced a form called Consent for Disclosure of Student Information for Superintendent Approved Purposes for parents to fill out. This form mentioned 9 types of student information, similar to what was shared before under the old policies. However, in the new policy, the school called this information personally identifiable information and said that parents needed to give their permission in writing before the school shared this information about their child. Once a parent signs this form, the school will assume they have permission to keep sharing this information in the future unless a parent decides to change their mind and tells the school in writing. So even though the information being shared stayed the same, the new policy now requires parents' consent before the school can share it. The revised consent form also outlined the types of requesters who could be granted access to this information, limiting it to those involved in school-directed events or activities like yearbook publication or theater presentations, as well as third-party educational, health service, or other nonprofit programs deemed beneficial to students by the superintendent. The court noted that the information School Choice Ohio requested was considered directory information under FERPA, which can be released without parental consent if certain conditions are met. Directory information under FERPA includes students' telephone list, email address, and grade levels. The school district did not have the discretion to redefine what is considered directory information beyond FERPA's definition. The school district cannot selectively withhold the directory information from certain unwanted questions. The court emphasized that FERPA does not permit the selective withholding of directory information based on the requester's identity or perceived intentions. Two things I'd like to add here. First, be careful with third-party vendors. Second, be careful when we post students' pictures on social media. Let's first look at third-party vendors. Digital tools and third-party vendors have increasingly become part of educational operations. The challenges of safeguarding student data have never become more significant. Well, FERPA provides a framework for protecting student privacy. It falls short in addressing modern threats of data breaches and cyber attacks. Recent years have seen a surge in such incidents, with schools and their third-party vendors becoming prime targets for cyber criminals. As administrators, we bear the responsibility for ensuring that third-party vendors handling student data adhere strictly to FERPA guidelines. This responsibility remains irrespective of whether a data mishap was intentional or accidental on the part of the vendor. A critical step in vendor selection involves rigorous scrutiny of their FERPA compliance practices, including how they provide data access to parents and students and safeguard against unauthorized access. The allure of free online educational tools can be tempting, but it's important to scrutinize the underlying costs associated with the free resources. Some third-party vendors may operate by monetizing student data through data mining practices, a clear violation of FERPA. This not only compromises student privacy, but places the school in the precarious legal position. To navigate this landscape effectively, schools should first conduct a thorough due diligence on potential vendors, focusing on their privacy policies and FERPA compliance measures. Second, demand transparency in how vendors collect, use, and share student data. Third, establish clear contracts that articulate data ownership, permissible data uses, and the steps vendor must take to secure data against breaches. Fourth, educate stakeholders, including staff, students, and parents, about the importance of data privacy and the measure the school is taking to ensure it. When using social media, educators and administrators must exercise increased caution to avoid inadvertently violating FERPA. While FERPA does not explicitly mention photographs, the U.S. Department of Education has clarified that photos can be considered part of students' education record if they directly identify the student and are maintained by the educational institution. Therefore, posting a student's photo on social media without consent could potentially violate FERPA if that photo reveals information protected under FERPA. When posting student photos, educators should minimize the identifiable information. For example, posting a photo of students working on a group project without tagging names or specifying the class can reduce privacy concerns. Instead of detailing the event location and student names, use generic descriptions that describe achievement without compromising privacy. For example, you can post, "Our students engage in an exciting hands-on learning experience this week," accompanied by a photo of students from the back or side, where faces are not clearly visible, or using photo editing to blur faces. By adhering to those guidelines, educators can navigate the fine line between showcasing school activities and respecting students' privacy rights under laws like FERPA. One more suggestion. When you're about to send an internal email to someone in your institution, especially you are attaching a document or replying to all, pause for a moment. Ask yourself whether the information you are about to share is truly necessary for everyone on the recipient list.